Let's commence with business and immigration law updates. This is a presentation of the Khurana Law Firm located in Rockville, Maryland. Here, the Chief Attorney and Counselor at Law is Attorney Ramesh Khurana. This week, Attorney Khurana is accompanied with Moderator Attorney Kenneth Haber. Attorney Kenneth Haber questions Attorney Khurana on how to avoid the requests for evidence for immigration petitions. In other words, Form I-140. Let's have a look.
Welcome to Capitol Forum. I'm Kenneth Haber, the moderator today, and with me is Attorney Ramesh Khurana. Welcome, Ramesh.
Thank you very much, Ken. I appreciate.
Ramesh is an immigration attorney with clients across the country and across the world. He's rather well known, to say the least, and he has excellent credentials.
Thank you so much for your generous introduction, Ken, as always.
It's my pleasure, and you earned every word.
Thank you so much. Really appreciate it.
Ramesh, can you give our viewers an idea of how to avoid requests for evidence and immigration petitions, the immigration form I-140? And is it really scary for people when they get this type of request?
Yes, it is. It is, Ken. And I'll be very happy to tell you why there are requests for further evidence from the USCIS. Why we call it is scary, because the employee has already gone through a very difficult process, because you come to the stage of filing form I-140 when your perm application is already certified by the US Labor Department, and now the case has moved from the US Labor Department to another federal agency, USCIS. At that point of time, you just want to see the approval of the immigration petition. You don't want to see any request for further evidence. Now the question is, why do you get the request for further evidence? Answer is very simple. You made certain attestations while you filed the perm application to the Department of Labor. Now you are coming to the USCIS, you have to make sure that you prove, or I always use the term, persuade the USCIS that we are complying with all the attestations which were made on the perm application. If you fail to do so, then you have got to be scared.
I would imagine that those forms have the language in them that it's on penalty of perjury.
Exactly, and you know, chances of denials become very high if you get the RFE for I-140, and burden is on you to overcome those issues. Otherwise, you just fail, and you do not want to fail at this point.
Well, how do you successfully handle such requests?
You know, Ken, of course, you have to be very thorough while you are doing that job. Thorough in the sense, you are listing certain job requirements while you are filing the application with the US Labor Department. You are saying that this person should possess a minimum of bachelor degree in computer science, whereas you cannot even prove that person has a degree in computer science, or this person has a 3-year degree, and you said it's equivalent of US degree, and the person got his degree from India or China, and that is 3-year degree. So you are stuck unless you can have an evaluation report, and then you can prove it that, well, my degree is equivalent of 4 years. But now I tell you, Ken, USCIS has become very tough, and they have taken a very strong position that 3-year degree is not equivalent of US degree, which is 4-year degree. So they reject it outright, and I am not seeing any case getting approved based on 3-year degree. Now second thing would be about the experience. Now when we talk about the experience, Ken, it has to be a progressive work experience. Like you say, person is holding a minimum bachelor degree and then 3 years of work experience. The person must have worked for 3 years after obtaining his bachelor degree. If he worked during the school, that cannot be designated as a progressive experience. That application would fail. So we take care of all these situations.
Wow. So even if he was doing the same job while he was in school as after school, it wouldn't count while he's in school?
Because we said the requirement is a progressive work experience, and we are stipulating ourselves in the application that minimum job requirement is a bachelor degree. So, that means whatever work has been performed by the employee after obtaining his bachelor degree, only that will be counted.
Is a 3-year commerce degree considered an equivalent of a U.S. bachelor degree?
Now, again we touched this question in our response to the second question, but we can elaborate on this point. Like we are talking about the commerce degree, which is a 3-year degree from India. Just for your information, Ken, now Delhi University has just started a 4-year course in the commerce discipline. So, that is a welcome step, because those students who will be graduating from Delhi University, now they will be spending 4 years, and they won't have this issue at all, if at all they decide to move to the United States. But Indian 3-year commerce degree is not equivalent of US bachelor degree, and I tell you, if you are talking in terms of labor certification and you say that minimum job requirement is bachelor degree, and you are combining that degree with some other degree or with some work experience, I-140 is not going to be approved.
What's the concept of financial ability to pay in the terms of the I-140?
The concept of financial ability to pay is linked to the fact whether the employer has the financial strength, financial muscles to pay to the employee. If the employer says, I have to pay this person $80,000 a year, now he has to show whether he has got $80,000 as net income on his tax return or not. If he cannot document 80,000 net income on the income tax return, then he can use the alternative methods. Let's say.
What's the alternative methods? Because if the person's not there working, how is he generating income for that $80,000?
Okay. Now, you are referring to the situation that person is not working, of course, then that means that person's W-2 is not there. Then you can look at the second option, which is called the net current asset option. You look at the current assets of the company, look at the current liabilities of the company. Then you are reducing current liabilities from the current assets of the company. Whatever balance comes, that represents the net current assets. Then you can support and you can argue that financial ability to pay is proven from the net current assets of the company. But most of the times I have seen in my practice, Ken, that these employees are already working with the employers. So, if the employee is already working, then you have got the W-2 of the employee. Then you will take support from the W-2 of the employee and you argue, look, this employee is already working with the employer. Since he has already paid $80,000 to this employee out of his tax return, which is already accounted for in profit and loss account, and then you say that whatever is the net income of the company, that is after paying salary to the employee, and that is acceptable as per regulation for proving the financial ability to pay.
How is he working? And I'm sure there's a great explanation, but how is he working if he's back in India? Is it teleworking or?
If he is back in India, then he is not working, because then he is not getting paid. But if he is sitting here, we talked about the concept of H-1B, then he is hired pursuant to the approval of H-1B petition and he starts working with the company. This is the way most of the time things work out. A person is already hired on H-1B, and then when the employer is happy with the employee, and then he would say, okay, I am going to offer you a permanent position, and when you obtain your green card. And this process would start from the filing of the labor certification application, and after the labor certification application is approved, then we move to the next stage of filing immigrant petition, which is I-140.
So the individual's already there working, and he must have came over as a student or something like that, or how did he get over?
That's a good question. If a person comes here as a student and after completing his degree, that person is entitled for the OPT, which is called optional practical training, and that can be given for 1 year, or in some cases when he has graduated in math or science courses, and that person can have the OPT for 27 months. So, he may be working during that period. So, if he is working for the company, he is not even on H-1B status, but OPT status, sometime a person may be working on CPT. CPT is basically curriculum practical training, and then he is getting his W-2, because simple concept is that this employee has already been paid 80,000 that was charged to the profit and loss account of the company, and that is why the income of the company got reduced by 80,000. You are saying, I have already paid this amount, why I have to prove? I prove it by way of referring to W-2 of that employee. So, that is the way it works.
Very good. Are there other ways that the employee can be in the country and be working for the company prior to getting the H-1B visa?
Oh yes, so there are other different types of visas, like a person may be working on L1B visa, where you file the labor certification. If you do not file the labor certification, probably the person was working on L1A visa, and there is another type of visa which is called O visa. You know, like person with some exceptional qualification ability, they may be working on O1 visa. So, there must be some work authorization document with the person, and if the person has a work authorization and he has got his W-2, so you take the help of W-2 document and prove that this is the financial ability to pay.
I see now. It becomes clear when somebody with experience explains it to you.
My pleasure, my pleasure.
What can the employer do if the immigrant petition is denied?
Oh my God, that is a very difficult situation. It all depends at what phase, or rather I would say, because the person is having some non-immigrant status. Non-immigrant status means he is having H-1B status or you know, L1 status, and if he is running out of time, you know, like a person can be on H-1B for a period of 6 years, and if it was already 6th year, then probably he is out of luck, because he cannot extend his H-1B visa. So, but if he is within H-1B status or some other conditions are satisfied, I do not want to go into details because we do not have much time for this segment, but we will recommend to the employer that file another I-140 petition. Maybe we can overcome those grounds for which the petition was denied. It is a very interesting field, Gan.
It certainly is, and complex at that.
Yes, it is very complex, and we need to understand all the regulations and laws before we can even talk about these concepts.
It certainly seems that anybody who's going to be seeking immigrant petition status for an employee needs to contact an excellent attorney in order to be able to get through this morass.
Yes, this is what I advise my clients, that always discuss your immigration issues with your immigration attorney before you get into trouble.
Thank you very much.
Thank you very much, Ken. It has been a great pleasure being with you this morning, and I will again thank the audience for being patient with us. Thank you so much.
Thank you.
Thank you.